Hi, Ian here from RP Emery. Couples often wonder if it is possible to be legally separated but still living in the same house. It's a common question and the simple answer is yes. You can be legally separated while still residing in the family home. In legal speak, this is known as being separated under the one roof. Separating under the one roof is a practical option for many couples. Usually it's a choice made for financial reasons. If one party is going to leave the family home, they may not be able to afford the additional rent, particularly if they already have substantial mortgage commitments. Parents often decide it's in the best interest of the children if they continue to live under the one roof for a period of time. Perhaps the parties may not wish to move out until they have reached a formal agreement on the division of property and how they will deal with the family home. Whatever the reason, the law in Australia recognises that a couple can be considered to have separated even though they may still be residing in the same residence. It all comes down to the intention of the parties. One or both of the parties must intend to sever the relationship, and the parties need to physically separate by living separately and apart. If living under the one roof, physically separating may mean moving into a separate bedroom and disentangling the finances, for example by closing joint bank accounts. Arguments can arise if the date of separation is disputed, as has been the case in several family court matters. Couples generally experience difficulties over a long period of time, and it's often hard to determine at what particular point they actually separated. In many instances, couples will have had discussions about separating, but take some time before they actually arrive at the point of separation. Even in the course of those discussions, one partner may say that the relationship is over, but not act on that statement for some time. For there to be a separation, one party needs to communicate to the other that the relationship is over, and they need to act in a way that confirms that intention. In cases where a party moves out of the matrimonial home, it might be said that the move is both communicated and acted upon, depending on the circumstances. It's highly unlikely a separating couple will ever need to prove the date of separation to a court of law. However, for practical purposes, you will need to have a separation date to inform the relevant agencies such as Centrelink and possibly the Child Support Agency. If you later decide to file for divorce, you will need to be able to state the date of separation on your application for divorce. This is because an application for divorce can only be made if the parties have been separated for at least 12 months, and an officer of the court will check your application to ensure this requirement is satisfied. So it's well worthwhile for you to record the actual date that you formed the intention to separate under the one roof, and then acted on that intention to separate by physically separating. That is, moving to separate bedrooms in the house and separating your financial ties.